Okay, so here's what you need to know in the legal realm that happened this past week. First off, we were just talking about how more lawsuits need to get filed, but there's actually a hurdle that I don't think everybody's totally aware of. So FPC versus San Diego, it's in the Ninth Circuit right now. It's the California fee shifting law. October 10, 2024, which was last week, the Ninth Circuit dismissed FPC's appeal, our appeal, in the case, saying that we don't have a viable case because the defendants have not attempted to enforce the law and say they don't intend to. Now, here's what's going on. So what's the question here? Well, they passed a law after, it was a couple years ago. They passed a law saying that, hey, if you sue the state on a Second Amendment issue and you lose, then you owe the state all the legal expenses. So they're going to rack up all these hours and pay law firms and whatever. If you lose, then boom, you owe them the $250,000 they spent, or the $500,000 they spent, or the $1 million they spent. This is obviously an attempt to try to bankrupt people that are filing lawsuits based on the Second Amendment. So we're fighting this. The first fight was the Miller case. Actually, the Miller case was the assault weapons ban. But then they said, hey, wait a minute, before we can go further on this, we need to know, what's going to happen with, whether or not it's constitutional to hit us with legal fees if we're trying to, sue for our legal rights back. And that turned into the Miller 2 case, so they called it, which basically said, hey, are we able to proceed without you guys bankrupting us? So they're fighting it, and basically what the court is saying is, well, they're not actually technically asking for the fees, so you guys don't really have a case. So we're kind of in this limbo. It's tough to file a lawsuit if you don't know if we lose. By the way, it's not just you don't have to win the whole thing or lose the whole thing. Even if there's a piece of it and you lose, then they could hit you up with the fees. So the state's basically saying, well, they're not really asking for their fees and hem-ha and, skibbity-skibbity. So it's leaving us in this state of limbo. And before we can file a bunch more lawsuits, we got to figure out, hey, is this, where do we stand on this thing? Because this could easily bankrupt any organization.
So they're basically stating you don't have someone who's been fiscally harmed. You don't have damages. Is that the kind of what they're saying? Is
yeah. And the reason they're saying that, that's exactly what they're saying,
because they've not attempted.
Yeah.
So I'm just trying to flip this through in my head. I'm curious. I mean, you can't. Can you put a dollar? Because here's the thing. I can totally imagine there's going to be organizations that have chosen not to pursue justice.
Yeah.
Because of this.
That's already happening.
Right.
There are lawsuits that we want to file. And it's like, we can't do that until we know, can San Diego County gun owners be a plaintiff on a lawsuit if they know they're going to come after us for $1 million? We can't afford $1 million hit.
Right.
So, $500,000 hit, we can't afford that. So yeah, it's already making it to where you're not going to see as many lawsuits in the state of California. There may be some. I know there's a couple organizations that are going to move forward on a couple of different lawsuits, and that'll be announced later. But there should be a lot more happening, but for this fee shifting thing, it has to get figured out once and for all. Isn't that crazy?
What judges were on that panel?
I don't know, but they didn't like us. I know that. Barba versus Bonta. That's the California Superior Court. This is the gun owner data sharing case where they passed this law and said, hey, we want to take all this gun owner data and we want to give it to the University of California in Davis, and we want them to figure out how they can ban more guns. Well, surprisingly, we were a little uncomfortable with that. So Barba she's a San Diego County gun owners member. And of course, we're plaintiffs in that case. There was a hearing on the motions for summary judgment, and it's scheduled for April 2025. That was just announced. A lot of people want to know, hey, our information is being, compromised legally. What's going on with that? Well, we wanted everybody to know they finally have scheduled a hearing, and it's happening in April 2025, which everybody probably thinks, man, that's so far away. Well, in legal terms, it's a blink of an eye. It'll be here before we know it. So I wanted to give you that update. Gray versus Jennings. Delaware has an assault weapon ban that's actually very similar to ours. It has a list, it has features, plus it has a mag ban. It's all very California sounding. The case was, there was actually a lot of discussion. They just heard the case. There was a lot of discussion on public safety versus 2A, which is the old way of thinking. Bruin has changed that. So there are still attorneys, anti-gun attorneys defending municipalities and states saying, hey, public safety, think of the children, think of the children, think of the children. And the reality is their world has completely changed. So they asked the Supreme Court to take a look at this, and it could be one of the cases that's heard. The Supreme Court is actually, Delaware didn't respond. So FPC said, hey, we need you to take a look at this, review it, please. Grant cert is the term. We want the Supreme Court to take a look at this. And Delaware basically said, we don't care. We're not gonna participate. We don't want a response. We're not going to respond to FPC's request for the Supreme Court to take a look. Well, the Supreme Court is actually forcing Delaware to file a response by the end of the month.
Really?
Which is, I think it's a very positive move. It doesn't necessarily mean that they're going to take this case, but what it does mean is that they're very curious to know more about it. I think they're going to finally make a decision on assault weapons is really what I'm trying to say. So I don't know necessarily if they're going to take that case. Now, speaking of that, in St. Louis, Illinois, actually East St. Louis, Illinois, not St. Louis, Missouri, Firearms Policy Coalition had a big victory. Today, the Firearms Policy Coalition announced that Federal District Court Judge Stephen McGlynn has ruled in the FPC law case Harrell versus Rowell that the Protect Illinois Communities Act, the PICA Act, which was an assault weapons ban. It was a ban on semi-automatic firearms and their magazines. He ruled that it is unconstitutional, which is a huge ruling. In fact, he had a 168-page decision where he nailed the anti-gunners. I mean, it was not opaque in any way. It was crystal clear that Judge McGlynn was not happy with the gun ban and made sure that he made it very, very clear in his decision that it was unconstitutional. After considering all of the evidence and arguments, the court must take action as justice demands. That's a quote. The court said in its decision, quote, PICA, that's the name of the assault weapons ban, the Protect Illinois Communities Act, is an unconstitutional affront to the Second Amendment and must be enjoined. The government may not deprive law-abiding citizens of their guaranteed right to self-defense as a means of offense. End quote. However, the court also stayed the injunction for 30 days to allow the state time to appeal and seek a stay from the Court of Appeals for the Seventh Circuit. They seem to be doing that because, you remember Freedom Week?
Right.
Where he said, hey, mags are legal, and he didn't. He immediately, he said it's immediate, and then there was this huge rush, and then they said, no, it's not illegal, or they're not legal again. I think that they tend to be doing this on purpose. They don't want a big rush and confusion and push and whatever. They're trying to get to the end of the road without causing any more confusion. So I'll read one more quote on this because I really, really liked it. We are gratified that the court properly found that these bans violate the constitutionally protected rights of Illinois residents and visitors. As we clearly showed at trial, PICA fails even under the Seventh Circuit's misguided test that conflicts with the binding Supreme Court precedent. That's FPC President Brandon Combs, who's a fantastic guy. So, do we now have another positive decision in an assault weapons case?
Absolutely.
How cool is that?
Not that there's any big news on it, but I just like to throw out there I know you have lots of cases in the works and everything, but we have the Richards case is going to have a session right later this week.
Yes.
Correct?
Yep. And the Richards case is
the 10-day.
Yep. Exactly right. If you have a gun, why are you going through a 10-day cool down period?
Right.
Doesn't make any sense at all.
Just excited for that.
As am I. And that is all you need to know this week when it comes to our legal segment. Hey, it's Michael Schwartz from Gun Owners Radio. Thank you for watching. Don't forget to like and subscribe. Watch us every Sunday from 5 to 7. Go to gunownersradio.com for more information. Check us out on any podcast provider.